seated. Good morning. We have one case on the docket this morning. Case number 23-3333, Sanctuary Cannabis versus Florida Department of Health. Appellants, counsel, when you're ready.
Thank you, Your Honors. Good morning, and good morning to opposing counsel as well. May it please the court, my name is William Hall. I have the honor of representing Sanctuary Cannabis in this matter. I would ask to reserve 3 minutes for rebuttal, if I may.
Noted. Thank you.
Okay, thank you. The summary final order should be reversed, and the emergency rule at issue is invalid for 2 main reasons. The first is that both the department and the ALJ interpreted section 381-986-8B in a vacuum without consideration for other context within that section, specifically section 381-986-7D, which permits the department to charge a patient and caregiver identification card fee associated with the issuance, replacement, and renewal of those cards. That led to an arbitrary and capricious interpretation of the statute and an arbitrary and capricious rule. The second reason is that the department could have at least substantially accomplished the statutory objective of a financially self-sustaining medical marijuana program through lower regulatory costs from this rule, specifically a renewal fee formula that incorporated at least any patient and caregiver card fees that the department received and did not remit to Florida A&M University. I'll start with the arbitrary and capricious argument unless the court wants to go another direction. But it's been stated by this court multiple times, by the Florida Supreme Court. I believe Justice Scalia has said in the Reading Law Treatise that one of the main or most common interpretive errors is the failure to consider the whole text, looking only at words in a vacuum. I believe Justice Curiel put this very well in the very recent Dream Defenders case in the Florida Supreme Court, that looking at the context of a statute is not triggered by ambiguity. Context reveals the plain meaning of a statute. It's not something that you use that to create ambiguity or when you found it. You go immediately to context in every situation. And in this particular circumstance, the department reads 381-986-8B in a vacuum, finding that renewal and application fees from MMTCs have to bear the full financial weight of the medical marijuana program.
Well, why is that not the plain text, though, counsel? I mean, it's sufficient to cover the cost of implementing and administering this section. Why is that, at least on the arbitrary and capricious, why is that illogical?
Sure, and if, as in the Best Care case that we've cited and others, if Your Honor or this court were to only look at those words, you could reach that reading. But that's why you have to zoom out and look at the whole context of the statute. It's arbitrary and capricious in this circumstance because the same costs are being covered twice, specifically any costs associated with the renewal, replacement, or issuance of patient caregiver identification cards.
So if we were to say that they may be covered twice, what I'm thinking here is that administrative costs is sort of a fixed known thing. I don't know if you could tell me, for instance, what next month's violative fee number is going to be. We probably can know what the administrative expense is going to be. I don't know if you could tell me the categories of costs you want to bring into this calculation seem variable. The statutes use may, and we don't know what those numbers are in the same way that we know what the administrative costs are.
Well, the patient caregiver fee is set by rule, so that's not just something that's just willy-nilly. It might be this today or that tomorrow. That's a promulgated amount, and it has not changed for some time. If the department were to say at some point we are not going to charge a patient and caregiver identification card fee, then yes, you would have a scenario where MMTCs bear the whole weight. But for the formula we're talking about, you still have to incorporate that possibility in the rule, even if it ends up being a zero. Because what you have right now is a scenario where a very large number of patients are paying this card fee and the department is amassing profit. I'm not saying that it's any bad intention of the department, but that's what's happening. And that's what runs headlong into the second argument, which is the 120.52.8F, that the entire purpose of the APA is not for agencies to amass profit from regulated parties. But that's what's
Is that something
happening.
that's been stipulated too, that they're making a profit every month? Because I guess the other thing that I'm thinking with this whole calculation is they calculated something fiscal 21, 22. It ended, I guess, mid-year 22. Back half of 22, we had inflation at 9%, then 4%, then 3%. This is all compounding. And does this calculation even cover the costs? I mean, it could be 10% below what they actually need to run the program or something like that, looking at a CPI, PPI type deal post this calculation period.
It's always possible, and that's, I mean, we've got a promulgated rule setting the formula. It's always possible that that rule could need other factors, and the department actually in this case has very unique emergency rule authority where it can, without going through the full rulemaking process, amend that really at any time.
But I guess we don't really know that there's any profit being made. I mean, they could just be covering.
Yeah, I mean, what we have from, and this is stated, I believe this is in paragraph 28 of the final order, page 222 of the record, is what the summary order is dependent on is the idea that the department is entitled somehow to receive fees over and above the cost, over and above the cost to fund the program. What the ALJ found was if you don't essentially allow the department to make a profit off these card fees, you're taking from them what they're somehow entitled to because the statute, as the ALJ interpreted it, essentially wanted the department to accrue funds over and above what's noted purely in 8B. But that's antithetical to 120.52.8F, which is intended to charge the lowest possible regulatory costs on parties. In not factoring in that card fee in the name of allowing any agency to accrue funds, again, completely antithetical to the APA and simply doesn't work in the full context of 381.986. If the department, as it is now through a promulgated rule, is charging patients and caregivers a card fee, which right now it's $75, 10 of that goes to Florida A&M, so $65 per patient. It's a public record how many qualified patients we have in Florida, and it's a lot. $65 for each patient is essentially intended to accrue beyond, or that card fee is associated with the issuance, renewal, and replacement of those card fees. But under the department's interpretation of 8B, MMTCs are already covering that cost. So how could it be how could you ever have a reasonable fee relating to the issuance, replacement, and renewal of identification cards if MMTCs are already covering any costs associated with identification cards and everything else? That's I think, the question the department really can't answer. And that's where the context here, much like the Best Care case, where the statute said no more than 4 Medicaid plans per region, but when you look at another provision that says, well, actually there's circumstances where maybe an extra plan could be issued, things like that, where you have something in a vacuum that could be looked at one way, you have to zoom out and see the full context.
Would you agree that if the licensure fees had to, the department's argument, that they had to cover the cost of implementing, administering the section, then it would be prohibited from charging for the ID cards at all?
I want to be careful there because obviously we're not challenging the ID card
Sure.
rule.
Sure, this is just theoretical.
But in my view, if the department contends that MMTCs cover all costs, I don't know how you could ever have a reasonable card fee because those costs are already paid by the MMTCs.
Well,
Right.
I mean, it doesn't say, again, that they have to be sufficient to cover any particular cost. It just says they have to be a reasonable fee associated with the issuance. That's just how much it is as opposed to a completely arbitrary fee decided by the department at its whim.
Sure.
Isn't that one way of looking at it?
It could be, and we're not, again, challenging anything about the patient rule at this point. But what I would say is the only way, in our view, the card fee could be associated with issuance, replacement, renewal is by being associated with the cost. I think that's clear. I don't know that the department contends otherwise, but I don't see a different interpretation. And if, as I believe is the only interpretation of that provision, patients are paying that cost, a cost associated with the issuance, replacement, renewal, then you've got the same fees being paid twice. And at least then you run into a world where under 120.52(8)(f), you have more regulatory costs, or you have a lower cost regulatory alternative for MMTCs such as sanctuary. The department has not said how they interpret the terms substantially accomplished in that rule or statutory objectives. We believe that the plain text, in a bit of a roundabout way, of that provision requires you to look behind the intention of 381.986, which is, we believe the intent, and the ALJ agreed with this, was for a financially self-sustaining medical marijuana program. If that can be accomplished by a lower cost to regulated parties, then the department has to do so. It's a very pro-business provision to where the department or any other agency is not entitled to any fees beyond what they truly need to
And you're
even.
saying pro-business vis-à-vis those who are getting the cards. You want to shift the cost to those who are getting the cards. I mean, it seems like the costs you're talking about are zero sum. Either you're going to pay it or the cardholders are going to pay it, and you want to shift it that way.
I don't think it's about shifting the cost to patient. The patients are paying the same amount right now. If the department wants to amend its rule tomorrow and say, we're now only charging patients $10 that goes to Florida A&M, then there's no shift to the patients. There's a zero in the formula, and we're essentially in the same place. But that's not what's happening here. It's not about shifting the burden to the patients. It's about not allowing the medical marijuana program to be a profit center for the state, fueled by not only regulatory costs, but frankly by sick people. Because that's what's happening now is you've got, under this interpretation from the department, again, not saying it's for any improper motive, but you've got the MMTCs bearing the full cost of the program and then just pure profit off of what anyone with a qualifying medical condition pays.
Yeah, but that we don't know. Was there expert testimony as to what's really going on in running the numbers in the program?
No, Your
What do
Honor,
we have?
we reached a stipulation to decide this as a pure matter of law. But again,
We
there's
really don't know what the numbers are. Going back to what I asked earlier, we're just guessing.
we are not challenging in this case whether the calculation was accurate. What we're saying is that it's arbitrary and capricious to not account for any card fees charged, and that there is a lower cost regulatory alternative when you are charging those fees and amassing profit to not do so. And with that, I'd ask to reserve the remainder of my time unless there are other questions. Thank you.
Good morning, may it please the court. Ed Lombard of Lombard Miles on behalf of the Florida Department of Health. Let me start with the arbitrary and capricious issue. The statute on its face is clear as to what the renewal fee and what the initial application fees have to equal. They would like to turn to other sections and argue that there's some ambiguity, but there's no ambiguity on the face of 8B. And there's also no ambiguity on the face of 7D or 10F, which they refer to. And none of those three statutes talk about each other. They don't reference each other. They're independent, standalone. There's no conflict among them. They can all operate by themselves individually. So you don't need to turn as a court to interpretive principles to figure out what the legislature commanded of the department. And I use the word command because there's a difference in the language in 8B where they said you shall charge a fee for the initial applications, and you shall charge a renewal fee, whereas for the ID cards and for the fines, it's permissive language. It's may. You may charge a reasonable fee for the ID cards, and you may fine the MMTCs for violating rules, violating statutes, et cetera. So from our perspective, all this rule did was turn into a mathematical equation what was provided and commanded to us by the legislature in the statute in words. It said, figure out what your operating costs are, and then your fees for two things, because we seem to be focused on the renewal fee a little bit too much. We have to charge all applicants an initial fee, so some of those individuals or corporations may become MMTCs or not, and together with the renewal fee, both of those fees have to equal, right, what you're spending, and that's what the rule does. No
Not
challenge to the
exactly right.
calculation.
We're talking about fiscal years 21 and 22, so we're not talking about real-world, real-time expenses.
What
Are
it
we
do-
even getting at what the legislature intended here by doing it that way?
Yes, because when you look backwards, you're looking at actual costs, right? So year over year, the legislature will appropriate. They'll say, we're going to give you this year, make a number up, right? $40 million for your program. Well, Sometimes you spend 40 in the year and sometimes you don't, right? They give you 100 full-time employees, you can't find 10 because you can't fill the slots, you don't spend all of the money. What the rule does is it looks backwards and it says, okay, for the last 2 years, we spent X, based on, and it's in the rule, based on records of the department, DFS, et cetera, adds that up, subtracts out what we've collected from application fees, which is one of the two components of that provision in AB, and then that equals a number divided by the number of MMTCs that are existing at the time. That's your renewal fee. So it's always backward looking, and the reason it does that is so you actually capture the costs that were actually expended, versus if we had tried to do that rule in a way where you're looking forward, then you're not capturing costs, you're capturing budget, right? Because budget and what you actually spend aren't always equal. You may be given 40 by the legislature, but you only spend 38. So the way it's structured, you're actually capturing by a backwards looking mechanism.
It just seems like in a higher inflation environment that you're out of whack, it could be 10% or something.
Could be. No rule's perfect. You try your best at trying to capture what those numbers are based on the records you have, and you look at it backwards and move forward. But in terms of arbitrary and capricious, it's not illogical to look at the numbers, add those up. They're not challenging that we didn't use the correct numbers or that our math is wrong. They're just saying, well, golly gee, you're collecting a lot of money from the ID cards. That's really the sum and substance of their argument, is there's this revenue coming over here that you're not crediting to us. Correct, because that's not the mandate. The mandate was capture these costs here and charge them, and then you may charge a reasonable fee. No one has ever contested or taken the position that the fee charged for those ID cards of $75, which is close to what you get charged for a driver's license, is unreasonable in any way, shape, or form. They haven't challenged it, no one else has. There is revenue coming in, no doubt about that. The statute says if you collect it, it's coming in.
Would you push back on the idea that the department could have calculated it and taken the fees into account in the way that the appellants ask?
If you take the fees into account, that's the position we took below, and the ALJ agreed with us. If you factor those and subtract, then the fee charged for renewal and initial doesn't equal the cost of operating. It's kind of like if I have a job and I get paid $1,000 a month, and my home expenses, rent, utilities, et cetera, are $1,000 a month. I decide to go get a part-time job at night, and I make another $500 a month. My cost didn't go down because I'm making more money at night. I still have rent, lights, et cetera, of $1,000 a month. If I credit them the monies that are collected from ID cards, you're not capturing the costs. Costs and revenue are two different concepts, and the legislature was clear. Set a fee that captures the cost of implementing and administering the statute. We've done that. What they would like to do is say, well, give me credit. If I give you credit, then I can't comply with the mandate. And this is, the reason I started with the mandate versus permissive is because if you want to go down the road they want to go down of, well, they're charging all this money over here, well, if anything has to fall, it would be the ID card fee because that one's permissive. In every instance, as an agency, we have to comply with the mandate, the shall.
Well, does it need to fall if in order to comply with 120.52.8, if all this extra money is coming in? I don't know that it is, but.
Let's assume for argument's sake that there's a ton of money coming in. Let's assume that that money exceeds costs. Then their fee would be zero. And that's really where they're going with this. They're trying to lower, and this is what the LJ found, right? That by advocating to get credit for the ID cards, what they're advocating is for a lower renewal fee, for pushing the cost of administration to the patients, and it's actually doubly bad, if that's the right phrase, because they want credit for the fines that they're paying as well. So the MMTCs are fined for bad behavior, and they would like that credited in the equation as well for their renewal fee. So you're incentivizing bad behavior because it doesn't matter. I'm going to get credit on the backside when I go to renew. And that's exactly what the ALJ found was illogical, that the legislature has set up a structure where you're collecting all the costs on these initial application fees and renewal fees. And he found that, yes, there may be excess revenue. There may be excess revenue from the fines, which are punitive, and they need to be there to ensure compliance. And there may be excess revenue from the ID cards, but that's precisely, to use his phrase, what the legislature authorized.
It also seems there are differences in character. Administrative, you are sort of fixed and you sort of know what that is. I don't know what the fines are going to be for November next month. I mean, maybe they're constant, I don't know. but it seems like they're just different in character, that sufficient to cover is a more fixed, sufficient to cover administrative is a fixed-oriented thing. Fees and how many people lose their cards is something that's, or fees for violations and replacement cards is something that, I don't know, seems more variable.
I agree. The costs tend to be, because the way the budget works in Florida, tends to be more static year over year, whereas you're correct, fines are going to vary year to year depending on who decides to ignore rules and violate the statute. And the ID cards can fluctuate based on number of patients. You have less patients, you're going to have less ID cards. You have more patients, you're going to have more ID cards issued. Sometimes people renew their ID cards year over year, sometimes they don't. So you're correct in that those two, in terms of how they play out in the real world, are much more variable than the cost of our, full-time employees and the like, which tend to run pretty constant with some, increases or decreases based on legislative budgetary priorities for any given year, right? If we're short money, the legislature may take some down from the budget, or they may increase if they have excess.
Can I turn you to their second argument, the 8F, because certainly it seems like their way of calculating it would be less costly to the consumer. So why is that not the appropriate way to do it?
Sure, because then you wouldn't comply with the plain language of the statute, right? The statute says you shall, you're going to charge these fees that are sufficient enough to cover the costs. If you subtract from that, then it doesn't meet that requirement. That's number one. Number two, I think, and there is no, they didn't put on any expert testimony as Judge Osterhaus pointed out or otherwise, but if you assume the sort of a scenario where, and I think he's correct, there's about 900,000 patients, okay, $65 after you subtract FAMU, you're talking in the $60 million range. That can potentially exceed the costs of administering and implementing the program. And so when you do that subtraction, you can find yourself in a scenario where either the fee to renew is either de minimis or zero. And that, a zero or de minimis fee, doesn't comply with the mandate, which is why earlier I said if something's got to fall, it would be the ID cards and not the renewal fee, because one is a shall and one is a may. So if you want to say, look, department, you're not doing this right, the place we potentially, and I'm not saying we are doing it incorrectly, I think $75 is a reasonable fee for an ID card, but if we're doing it wrong somewhere, I think the better argument for somebody, not them, maybe a patient, would be that ID card fee maybe, is not right. But that's permissive. This one is mandatory. We've been given a directive. So reducing it, right, doesn't substantially satisfy the directive. And that's the standard under 12052F. Does it still substantially satisfy the objective? And I don't think you can substantially satisfy the objective in that scenario where the ID card revenue is equal to or greater than the cost of administering the program as a whole. So that's why I don't think that argument works for them. I agree. If you charge less, it's less burdensome on the regulated entity. Sure, okay, but that's not the legal standard. The legal standard is, are you still substantially complying? Our perspective, and it's what we argue below and in our briefs, is that, again, that language in 8B is a proxy for a number. Because as Judge Osterhaus has said, the budgets and the numbers can change year over year. So instead of putting a specific formula or number, they said, you guys figure it out. You're the guys that run the program. But whatever you do here, these fees have to be enough, sufficient enough to cover the cost of administrating the program. And again, the other reason why it doesn't substantially satisfy 8B, and I think this is something else the ALJ found, is because it's clear that the cost of administrating the program needs to be borne by the MMTCs, right? That's what 8B says. That's what the ALJ found. If you start crediting the patient fees and you start giving them credit for their own bad acts, that purpose is not satisfied. You're shifting, right? They're getting monies from the patients, right, by way of reduction in their renewal fee. So it doesn't square, and it therefore doesn't meet 120.52F. Third reason, and I'll stop with this one, is we don't view the regulatory costs as emanating from the exercise of rulemaking authority by the agency. We view the regulatory costs as emanating from the statute itself. right, because of the directive. They're saying, you shall charge this amount. Again, it's a proxy, and we created the formula, but it's not like your typical APA case where the agency is given some discretion, the reasonable fee, and they go and exercise that discretion. You say, well, hold on, it's $75, maybe it should be $50, and here are some factors you didn't consider, agency. That's not this type of case. This type of case is one where the regulatory cost emanates directly from the body that is imposing the regulatory cost is the legislature, not the agency by way of, for example, charge a reasonable fee. So for that third reason, it can't satisfy 12052.
So you have statutory authority to charge more, but you don't have statutory authority to charge less than what covers the administrative.
It's a floor. It's a floor. It's not a ceiling. And we're not going over it. It's not like the floor is $40 million and we're charging them, $100 million. We're trying by that formula, looking backwards, to be as close and as tight to the exact numbers going out as we can, within reason. But it is a floor, no doubt. We satisfy it with this number. We would satisfy it by a greater number, but again, the department's trying to hew as close to the directive as possible with this equation. Unless there's other questions, I've got about a minute left. I think, the ALJ's view of the statute was correct, and I understand it's a de novo for you all to look at that statute, but I think 8B is clear on its face. It doesn't conflict with 7D or 10F. They all can work independently of each other. You don't need to resort to interpretive principles. Giving them credit on the ID cards or for fines for their own bad acts does not substantially satisfy the objective of 8B, and so their alternative argument doesn't work as well. So for all these reasons and the reasons in our brief, we ask that you affirm the order.
Three quick points, if I'm able. When my esteemed colleague talks about not resorting to interpretive principles, the Florida Supreme Court has told us mere months ago that you do not wait until you're confused to consider a statute's context. So you don't, looking at Section 8B in a vacuum and saying it's clear we don't have to do anything else is the exact opposite of what the Florida Supreme Court has told us to do.
But why in the context of 8B shall language isn't the proper challenge in this area really to the fees brought by a cardholder instead of on the MNT side, which is a shall cover these expenses?
If this court holds that MMTCs have to bear the whole weight of the program, then I could see some patient saying, why do I have to pay this $75? That's certainly possible. But I would also say the idea that this rule is just a number purely derived from statute is wholly incorrect. Even if you read 8B the way the department does, it's the combination of application and renewal fees that is supposed to pay all these costs. The department has decided to set just a static application fee. When we talk about fluctuation, the idea, if the department is accepting applications, then there will be a significant amount of money in that bucket. If they don't, it'll be a zero. So everything about this will fluctuate. The question is, we have a known significant stream of regulatory costs coming in to the department. And as 7D says, those are costs associated with the issuance, replacement, renewal of identification card fees. We're not here arguing for a $0 renewal fee. That's not our intention. We're asking, as every regulated party does, and as is the purpose of 120.52.8F, for a lower cost regulatory alternative. That's the exact purpose of the statute. So the idea that this is a floor that we can, we'll try to cover our costs, and if we get something above that, that's great. That's not the purpose of the APA. The APA wants regulated parties to pay the lowest possible regulatory cost. If the department chooses not to charge a patient and caregiver identification card fee, then MMTCs will bear the full weight. But as it stands now, with significant money coming in that way, it is contrary to the APA to not consider that lower cost regulatory alternative.
Can I just ask you a procedural question? The costs were due January of this year. Did Sanctuary actually renew its license and pay the cost?
Sanctuary did, but then will be up for renewal 2 years from now.
No, I wasn't contending it was moot. I guess it would be moot if you just abandoned the license.
Right.
But that was the reason for the question.
Right, and that will also fluctuate, so when people renew will cause fluctuation as well. Thank you, Your Honors.
All right, that concludes our session for this morning. We're adjourned.
All rise.